Hello everyone, very warm welcome to StudyIQ IS English channel. I am your host, your educator, your teacher, Praveen Mishra. And let's quickly go ahead with the topic for the day. That is how the judicial review and the PILs, that is public interest litigations, they do help us in establishing the welfare state. Who is to be accorded with the responsibility of creating welfare state? Is it legislature, executive, or judiciary? Or it shall be any two of them or all three of them. So to answer this question, it is yes, the simplest of the question, and so the simplest of the answer. All the three wings of the democracy, they are accorded with this one particular task, that is to establish welfare state. Yes, utopia is not possible. Utopia is a dreamboat. Utopia, in fact, is a imagination as well, where nothing wrong can happen, where everything is perfect and fine, where everyone is rich and flourished. So that is an imaginary world, as much as visualization as you can have, that is known as utopia. On the very opposite side, there comes the realistic term, that is welfare state. What is welfare state? Welfare state is just like utopia, that everyone is flourished, everyone is having all the basic amenities. But it talks about reality. It says that if anything wrong happens with any individual, I'll repeat it again. If anything wrong happens with any individual or group of individuals, that is communities, then immediately the grievance should be redressed, the justice should be served, the justice should be delivered. This is what the logic behind welfare state is, and this is how the welfare state and utopia, they are differentiated, right? And how the welfare state begins. So, is there any constitutional provision inside our constitution? Is there any judgment related to it by the honorable courts of India? Yes, obviously there are. So, starting with the first ever provision, the concept of welfare state has been explained by the Supreme Court in its judgment in the case that is known as Lalaram versus Union of India case 2013. In this case, Supreme Court gave clear-cut definition of welfare state, and this is what is written here. It contemplates a setup wherein the weaker sections of the society are accorded not just economic, political, and social rights, but, as I stated in the beginning, also special protection measures for their welfare and upliftment is given. So this is what the Supreme Court's ruling has come through the case. The case name is Lalaram versus Union of India and others, that is 2013. Okay, so now we know it very well that there is an actual definition existing, constitutional definition existing for us for the theory that is known as welfare state. Now, when we talk about the doctrine of separation of powers, as we can understand it with this thing here, what is separation of powers? The theory was given by a French political philosopher in his book Spirit of Laws. His name is Montesquieu. Montesquieu said that the democracy has got three organs. That is, the one is legislature, the other one being executive, and finally the third one, judiciary. So, Montesquieu called this theory as the theory of checks and balance, or the theory of separation of powers, that it says all the three wings, they do work independent of each other and do not interfere in the matters of each other, but they do check each other and balance each other, hence the name, the theory of checks and balance. So what is the role of legislature? To make laws. What is the role of executive? To execute or implement the laws. And so, lastly, what is the role of judiciary? Simple role, once again, to interpret the law as well as to defend the law as well. So this is what the theory of separation of powers. And all of these three wings, they are accorded with one single power, or one single aim or target. That is the establishment of not utopia, but at least welfare state. Right? So in that sense, we have got this paragraph here. The doctrine of separation of powers is not an embargo on the courts to review executive policies. While formulation of policy falls within the domain of the executive or legislature as well, courts can very much examine whether a government policy meets the standards set by our constitution or not. And so, for that sake, in order to establish welfare state, the courts are accorded with some great powers. Like, for example, the first one is the judicial review, and the other one is known as PIL, that is public interest litigations. What is judicial review? See, for example, whenever we go to watch a movie or buy any XYZ product, we do go ahead with the reviews, right, over the internet. That how much rating this particular movie has been given out of 10 out of 5, how much rating this particular product has been given out of 10 out of 5, what are the customers' feedbacks, what are the viewers' feedback, and so on. And then only we decide whether to watch the movie or not, whether to buy the product or not. Okay, that whether the product is worth the cost it is. So this is what the general review is. Now the word here is judicial review. What is the judicial review now? So whenever a law is passed by the legislature, or whenever a law is implemented by the legislature, the judiciary monitors it. Monitors it in a way that whether the passage of the law or the implementation of the law, that is the construction of the law and the implementation of the law, both are done in accordance with the principles of the Constitution or not. If done, that's okay, that's perfect, fantastic, keep going. But if not, then the judiciary possess absolute power to declare that particular law immediately as null and void. I'll repeat it again. If the law is made and implemented according to the principles of the Constitution, then it's perfect, fine, no problem in that. But through any corner, through any edges, if that particular law in the implementation or in the formulation is violating any of the principles, any of the provisions of the Constitution, then in that case, judiciary possess absolute authority to declare that law immediately, mark my words, immediately as null and void, without any discussions and delegations with any other wings of the democracy. This is the sole authority that lies into the hands of judiciary, so that they can also contribute in the establishment of the welfare state, so that they can check a particular law is not made that infringes or abrogates the rights of the individuals or the community as a whole. Right? So this is what judicial review comes in. And the history of judicial review is also very important and interesting. A case happened in America in the year 1809, known as Madison versus Marbury, in which, or through which, we can say the doctrine of judicial review emerged. It was enunciated by the court that a law that violates the Constitution is unconstitutional. And the language used in the Constitution of the United States affirmed and strengthens that any law contrary to the Constitution is void. And who possesses the authority to declare that law is void? It is simply the judiciary, the Supreme Court and the High Courts, both in the context of India. Okay. Now, the very next measure, that is known as PIL, public interest litigation. You might have watched that very famous movie known as Jolly Lilby. Two parts of the movie are there, 1 and 2. And they both are based on these three alphabets, PIL, public interest litigation. In case there is an issue which has not yet came to the notice of the authorities or any of the wing of the judiciary, and no such case has been registered against that issue as well, or to solve that issue as well, then in that case, each and every individual citizen, I'll repeat, each and every individual citizen possess the authority to knock the doors of the judiciary, from subordinate courts to high courts to Supreme Court directly, even one can go and ask the judiciary that, sir, my lord, Justice, Judge Saab, this is the case, and please, we need your intervention and your fine sense of judgment and wisdom to solve the issue. And the judiciary shall act accordingly, for sure. Right? So what is PIL? What is the genesis? What is the origin? Let's discuss this. Okay. See, the expression public interest litigation has been borrowed from the American jurisprudence, wherein it was designed to provide legal representation to previously unrepresented groups, maybe the poor or the racial minorities, the unorganized customers, or any other citizens who were passionate about the environmental issues or any other such issues, etc. So if you are thinking that there is a particular project going on or a construction going on or any type of activity going on that is troubling the environment, the greenery, or it is enhancing the pollution or disturbing the lives of others or education system or whatsoever, but it is not a case yet, then you have got a tool with yourself that is known as PIL, public interest litigation. You can go directly to the subordinate courts in your district. You can also bypass the subordinate courts and directly approach to the high courts in your state, or even you can approach directly bypassing high courts to the Supreme Court. This is also your sphere of authorities you possess, being the citizen of the great nation that is India. Right? So PIL, that is litigation filed in a court of law for the protection of public interest against issues such as, for example, pollution, terrorism, road safety, constructional hazards, etc., or any of them, or any particular XYZ thing that you think that could be a potential public safety issue. So you can go directly to either subordinate courts, high courts, or directly to the Supreme Court as well. Okay. So as we can see, the further of the static points that we need to understand, public interest litigations is not defined in any statute or in any act. Remember, guys, no law is there for PILs, right? It has been interpreted by judges to consider the intent of public at large. So PILs, they are not backed or supported by any statute or law, or not even by the constitution. They are a tool provided by the judiciary itself to the masses for the sake of establishment of welfare state, simply. Public interest litigation is the power given to the public by the courts. That's it. And as you can see this line here, the court can itself take cognizance of a matter and proceed suo motu. Suo motu as in on its own. In fact, if there is no litigation, suo motu word, it means on its own. It's a Latin phrase which has a literal meaning in English, that is on its own. Right? So in fact, if there is no petition filed, no litigation, no appeal has been filed in front of the court, and still court sees that, or the judges sees that the particular public interest issue is going on, then courts, they themselves can file a petition to themselves and can go ahead with the proceedings against such an issue whatsoever it is. Okay, so the highlight of the story is from where this PIL started in India. So it started with the case that is started by Justice Krishna Iyer in the year 1976 in Mumbai, in the case known as Kamgar Sabha versus Abdul Thai. Nahi, wo Abdul Bhai nahi, it's not Abdul Bhai. Don't think that it is a mistype. No, it is Abdul Thai only. So the first case through which PILs came into physical existence in India, and now they have become a metaphysical thing for us when it comes to the concept of welfare state. Okay, so this is what Kamgar Sabha versus Abdul Thai. Further, it was enhanced in the another case 3 years just later in 1979, that is known as Husainera Khatun versus the state of Bihar, which focused on the inhuman conditions of the prisons. And then next, it was stated that right to speedy justice emerged as the basic fundamental right which had been denied to the prisoners. So the evolution of the PILs in India started in the year 1976 with the Kamgar Sabha versus Abdul Thai, provided much impetus with Husainara Khatun versus State of Bihar 1979, okay, which was with regard to the state of prisons and the prisoners, and then came into the list the champion of PIL movement in India, Justice P.N. Bhagwati. So as we can see what is stated here, a new era of the PIL movement was heralded by Justice P.N. Bhagwati in the case known as S.P. Gupta versus Union of India. And in this case, it was held that any member of the public or social action group acting bona fide can invoke the writ jurisdiction of the High Courts under Article 226 or the Supreme Courts as well under Article 32. Right? So Justice P.N. Bhagwati is often considered as the champion of the PIL movement in India. Okay, guys. So please remember the facts that we have discussed. So let's have it once again here. So when you talk about evolution of PILs, so it was initially Kamgar Sabha versus Abdul Thai. What was the year? 1976. Then impetus was given or boost was given by the case known as Husainara Khatun versus State of Bihar, 1979. And then finally, it was Justice P.N. Bhagwati. So with this PIL, any matter that is a serious public issue but still has not been highlighted, has yet come into the notice of the authorities, including judiciary, we can approach it. We can approach directly to the Supreme Court or the High Courts as well, and yes, obviously the Supreme Courts, so subordinate courts as well, and can ask the judiciary to deliver the justice and serve the nation and establish the welfare state. So the PILs and the judicial review, they are the mechanisms, the tools that are provided to the judiciary when it comes to the establishment of the welfare state, when and if in case the legislature and executive fails to do so or violates any of the principles of the Constitution. Okay, guys, so this is it from my side in this session. Thank you so much for watching. Please do subscribe the channel and do provide your valuable feedback about the session. And please do let me know, in fact, any of the topic you want me to create a session, to create a video on. So I will for sure take action over that topic for sure. Okay, guys, thank you so much. See you all soon. Bye-bye. Take care. Study well. Jai Hind.